what are the main legal principles that apply to every space activity? First, we have in Article 1 of the Outer Space Treaty, it says that there is freedom of exploration and utilization, which means that if you can get to the outer space, you're free to explore it and to utilize it. And this is an important principle because we'll come back to it when we're going to talk about remote sensing. There is also no discrimination of countries based on their level of economic development. So everybody is free to use and to explore outer space. And one very important and neat wording that is used in Article 1 is that it says that outer space is province of all mankind. So it belongs to everyone. And we only have three such definitions in international law, one being for high seas, the other being for Antarctica, and the third one being for outer space. There is some debate if perhaps climate is going to be also defined as province of all mankind, but that has not still been regulated. Article 2 of the Outer Space Treaty says there is non-appropriation principle, which means you cannot buy land on the moon, you cannot be an owner of anything on celestial bodies because it doesn't belong to anyone, or it belongs to everyone, no one can sell it. So even if Elon Musk gets to the Mars and builds a community there, he'll only have ownership of the structure that he has built, but not of the land of the Mars. Article 4 says that no state should deploy nuclear or weapons of mass destruction in outer space. So this is the only explicit provision saying what type of weapon is not allowed to be placed in outer space. It goes further to say that moon and other celestial bodies should be used exclusively for peaceful purposes. Now, this is also a bit of a vague principle because even though it says it should be used only for exclusively peaceful purposes, there is terminology debate if peaceful purposes also allow militarization and only prohibit aggressive behavior in outer space, which means you could still deploy military satellites, but you should not use any structure in outer space as an act of aggression. Due to this interpretation of the principle, we are seeing nowadays that Trump announced Space Force. Japan is the latest one who is also announcing they're going to build a Space Force, France as well, because they're saying this is not prohibited. This is still part of the peaceful purposes. Article 6 of the Outer Space Treaty is especially important for anyone who is interested in building, as a private person, a small satellite, for example, and launching it into outer space, because we're seeing that that's nowadays more and more economically possible to do. It's not that expensive as it used to be. There are CubeSat satellites, which are very small and can be launched together with bigger satellites, so you're actually not even paying the full price for the launch. Article 6 says that countries are internationally responsible for national space activities. What does that mean? That means that no matter if it's a governmental activity or a private person activity, the country of that national is going to be internationally responsible for the activity. So even though if a university builds a satellite and wants to launch it, or you as a group of engineers build a satellite and want to launch it, Serbia is going to be internationally responsible. And because it's internationally responsible, the requirement for you to engage in such activity is regulated by national laws, and it should require some kind of authorization, licensing, and continuing supervision. Because if something happens, for example, your CubeSat hits another satellite in outer space, let's say a French one, France is going to sue Republic of Serbia, and they can pay a lot. So usually states actually ask that you have a huge insurance coverage if you're engaging in such activity, because if they have to pay, they want to be able also to get reimbursed from you. Article 7 says who is liable for the damages, and that is the launching state. There are 4 criteria how a state can be a launching state. It's the one who launches the satellite, the one which procures the launch, or the one from whose territory or facility a satellite is launched. So just to give you an example, if Serbia wants to launch a satellite, they're going to use some available launcher, let's say from India. And India can launch it from a platform in the sea, which maybe is in territorial waters of Sri Lanka. You would have then 3 actually launching states possible. So they need to agree which one is the launching state, which is going to be then registered at the United Nations. And then you know if something happens, who you can send your claim to and ask for the damages. Article 8 says that the launching state, the one that registers, is the one that retains jurisdiction and control of the object as long as the object is in outer space, which means even though if Serbia sells after a while satellite, it will still actually be the one noted down as the one who has jurisdiction and control. And Article 9 encourages cooperation in outer space, that states should cooperate as much as possible and have due regard to one another and the activities that they are conducting. Now, these articles are very important because, as I said, they apply to any type of space activity. Now, taking a more detailed look into legal principles that are applicable to remote sensing, I want to point out that first, after the 5 treaties have been adopted, so the last one, which was in '79, there has been no other international treaty adopted. So remote sensing principles are actually coming from a resolution, United Nations resolution, which means, first of all, that it's not binding. And I'll get back to this. So there is, if we are observing atmosphere, land, and ocean, huge amount of data is being produced. And this is called so-called big Earth data, which is characterized, and I have to read this because the lawyers are not the only ones who can come up with really long definitions. Big Earth data is characterized as being massive, multi-source, heterogeneous, multi-temporal, multi-scale, high-dimensional, highly complex, non-stationary, and unstructured. So in order for anyone to use this highly complex data, you need to have an infrastructure in place. You need to have infrastructure in outer space. You need to have it on ground. How can you process this data? And because this was, again, a big debate between countries which had the infrastructures and the ones that didn't, mainly because developing countries were faced with 4 challenges: not having infrastructure nor expertise, having poor access to data, too little cooperation, and the digital divide was being developed between these countries and the ones that have. They started talking about what were their rights, how to get to these data, and how can they use the infrastructure that someone else is having. And they were also saying, well, if we're being monitored from outer space, we have some rights because you're monitoring us and we want to have access to this data. So this took a long, I think over a decade of debate. They couldn't agree. That's why it came in a resolution, so non-binding law, which was seen as a compromise between the developed and the developing countries. So we have the general rules, which I mentioned before, that you have freedom of exploration and utilization. So anyone is free to launch a satellite construction into outer space, which can be used to monitor any place on Earth. And you're internationally responsible for it. and you should cooperate. So those are the general principles. But the treaty does not say anything about, do you actually have the right to ask someone for the data, or do they have to share the data with you? So the remote sensing principles, they say that the sensed state, sorry, just a second, sensing state should make available primary processed and analyzed data that is in its possession to the sensed state on a non-discriminatory basis and on reasonable cost terms, taking particularly into account the needs and interests of the developing countries. What does this basically mean? This means that this doesn't give any special treatment to the sensed state, nor can it amount to a legal obligation. So there is no legal obligation to demand data access, nor demanding it for free. So you're stuck with what the state that is observing you is willing to offer, basically. You don't have any legal means to say you need to share this data with me and you need to give me for free.